My son sold my beach house and my car to pay off his debts. When I returned, he mocked, "Congratulations! Now you're homeless." I smiled. He didn't know that this house was actually— Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. I spent 31 years being careful with money. That was what people never understood about me. They looked at the beach house on Sullivan's Island, at my white Buick in the driveway, at my little garden with the hydrangeas, and they assumed I had always been comfortable. But comfort like that doesn't fall from the sky. It comes from decades of packed lunches and secondhand furniture and saying not this year when the grandchildren asked for Disney World. My husband Roy and I built everything we had with quiet discipline. When Roy died of a stroke 11 years ago, he left me with a paid-off house in Charleston, a modest savings account, and a beach cottage on Sullivan's Island that we had bought in 1987 for reasons that had everything to do with love and nothing to do with investment. I kept working as a bookkeeper until I was 65, and then I retired, tended my garden, read my library books, and tried not to be a burden to anyone. Derek was our only child. I want to be fair to him, even now. He was funny as a boy, quick-witted, charming, the kind of kid who could talk his way out of anything. Roy used to say that was a gift. I came to understand it was also a warning. By the time Derek was in his 30s, the charm had curdled into something else. A pattern of borrowed money, collapsed business ventures, and explanations that were always almost convincing. There was the landscaping company that would have worked if the partner hadn't stolen from him. There was the bar he co-owned in Mount Pleasant that closed after 14 months. There was Brittany, his wife, who had her own talent for spending money that didn't exist yet. I loved my son. I want that on the record. I loved him the way you love someone whose flaws you understand completely and forgive anyway. The first sign I should have taken more seriously came 18 months before everything fell apart. Derek called me on a Tuesday evening. He only ever called on weekday evenings when he needed something, and asked very casually whether I had ever thought about simplifying my estate. He said he had been reading about probate. He said it might be easier for everyone if certain assets were transferred into a joint arrangement before something happened to me. I told him I had a will, drawn up by my attorney Tom Hargrove, and that everything was in order. Derek laughed and said, of course. Of course he was just thinking about saving me trouble. We talked for another 10 minutes about nothing, and then he hung up. Why didn't I trust that feeling in my stomach that night? Maybe because he was my son. Maybe because doubt feels like disloyalty when it's pointed at your own child. The second sign came 6 months later. Derek asked if he could borrow the Sullivan's Island cottage for a few weeks while he sorted out some financial unpleasantness. I agreed. What I didn't know was that a few weeks became 4 months, and that during those 4 months he had apparently been showing the property to people I had never met. I found out about that by accident from my neighbor Carol Whitmore, who mentioned over the phone that she had seen a young couple with a real estate agent walking around my cottage on a Thursday morning. I called Derek. He said Carol was confused. He said it was probably the neighbor's place. He said it so smoothly that I almost believed him. Almost. I had planned a trip to visit my sister Ruth in Savannah. 10 days. Ruth was recovering from a hip replacement and needed company. I kissed my hydrangeas goodbye, asked Carol to keep an eye on things, and drove south in my Buick. I came home on a Friday afternoon in October. The Buick I came home in was Ruth's car, because my Buick was gone from the driveway. I stood on the front porch of my Charleston house with my suitcase, and I called Derek. He answered on the third ring. "Mom," he said. There was something in his voice I had never heard before. Not guilt exactly, but the specific lightness of someone who has already decided he has won. "Derek, where is my car?" A pause. Then, in a tone that was almost playful, "Mom, I need you to stay calm. There were some debts, some urgent situations. I had to make some decisions." "What decisions?" "The cottage is sold. The Buick is sold. I know this is a shock, but honestly—" And here he actually laughed, a short, bright laugh that I will hear in my memory until I die. "Congratulations, Mom. You're basically homeless now." I stood very still on that porch. The October sun was warm on my face. A mockingbird was singing somewhere in the hydrangeas. I smiled. Not because it didn't hurt. It did. God, it hurt in a way I don't have words for. I smiled because Derek, in his cleverness, had made one enormous mistake. And in that moment, standing on my own front porch with an empty driveway and a gutted heart, I knew exactly what it was. I didn't go inside right away. I sat down on the porch steps. The same steps Roy had painted white 3 separate times over the years because he could never find exactly the right shade. And I let myself feel it. All of it. The betrayal, the humiliation, the specific, nauseating grief of being wronged by someone you made. Derek had sold the Sullivan's Island cottage. The cottage Roy and I had bought for $42,000 in 1987, which by last year's market was worth somewhere north of $800,000. He had sold my car, a 2019 Buick Enclave I had paid for in cash 2 years ago, worth about $26,000. He had done this while I was in Savannah, caring for my sister, because he had calculated, correctly, that I would be gone long enough for the transactions to close. That was the arithmetic of my loss. Over $800,000. Gone. Transferred to pay off debts I had never been consulted about by a person who had no legal right to touch either property. Or so Derek believed he had. Did he know what he had actually done? Did he understand the specific legal geography of what he thought was his to sell? I was a bookkeeper for 31 years. I understood paperwork. I understood the difference between what a document says on its face and what it actually means. But I am getting ahead of myself. That afternoon, sitting on those white-painted steps, I was not yet calculating. I was grieving. There is a version of this story where I call a lawyer immediately, where I am sharp and tactical from the first moment. That is not the true version. The true version is that I cried. I cried quietly, with the mockingbird still singing, until the sun moved behind the neighbor's oak tree and the porch fell into shade. Then I went inside, put the kettle on, and called my friend Diane. Diane Beauchamp had been my closest friend for 22 years. We had met in a church choir in 2002 and discovered we were both recently widowed, both suspicious of casseroles brought by well-meaning neighbors, and both constitutionally unable to pretend things were fine when they weren't. She was 71, retired from nursing, and she had the particular clarity of mind that comes from 40 years of emergency medicine. I told her everything, start to finish. She listened without interrupting, which was one of her great gifts. When I finished, she said, "Peggy, before you do anything else, you need to know exactly what was sold and exactly how." That was the sentence that cut through the grief and started the engine. The next morning, Saturday, I drove Ruth's borrowed car to my attorney's office. Tom Hargrove didn't work Saturdays, but he had given me his cell number years ago after Roy died, and I used it. He picked up after 2 rings. I explained the situation in the flat, factual voice I used to use when presenting quarterly accounts. Tom listened, asked 3 precise questions, and then said, "Come in Monday morning, 8 o'clock. Don't talk to Derek before then. Don't confirm or deny anything. Just listen." I spent that weekend doing something Derek would not have expected. I was not panicking. I was documenting. I went through every paper file I kept in the fireproof cabinet in my bedroom closet. I was looking for a specific set of documents: the original deed to the Sullivan's Island property, the title paperwork for the Buick, and a particular letter that Tom Hargrove had sent me in 2019. I found all 3 within the hour. I photographed each page with my phone and emailed the images to Tom and to my own email address as backup. Then I called the Charleston County Register of Deeds. Their offices were closed for the weekend, but I knew from years of professional habit that property transfer records are public. I found the online portal and searched the address of the Sullivan's Island cottage. There it was. A deed transfer recorded 11 days ago. The seller was listed as Derek Roy Callahan. I stared at that name on my laptop screen for a long moment. Derek Roy Callahan. Not Margaret Ann Callahan. Not the Callahan Family Trust. Derek Roy Callahan, acting as sole owner. Here was the thing Derek did not know. The thing that was going to matter more than anything else in the months ahead. In 2019, after a long conversation with Tom Hargrove about estate planning, I had restructured how the beach cottage was held. It was no longer in my name alone. It was held in a revocable living trust, the Roy and Margaret Callahan Family Trust, of which I was the sole trustee. Derek's name appeared nowhere in that trust document. He had no authority to sell, no power of attorney, nothing. What he had done, in legal terms, was sell a property he did not own. That is called fraud. I closed my laptop. I made another cup of tea. I sat at Roy's old kitchen table in the house we had shared for 28 years, and I understood that what was coming was not going to be simple or quick or painless. Derek had a wife who would fight alongside him. He had lawyers he'd used before, not good ones, but ones willing to be aggressive. He would claim confusion. He would claim I had verbally authorized the sale. He would do what he always did: talk smoothly and loudly, and wait for everyone to get tired. But I was a bookkeeper. I understood paper trails. And the paper trail here was going to tell a very different story than the one Derek intended to tell. My first plan was simple. Establish the fraud before Derek realized I knew the full legal picture. Get Tom engaged formally. Get law enforcement notified before Derek had time to move money or destroy records. I was 68 years old. I was widowed and temporarily without a car. I was also, I realized as I rinsed my teacup at the kitchen sink, angrier than I had been at anything in my entire life. Good. I was going to need that. Sunday passed slowly. I went to the 11 o'clock service at St. Philip's, sat in the same pew Roy and I had shared for 20 years, and prayed. Not for forgiveness toward Derek. Not yet. But for clarity. For steadiness. For the kind of patience that outlasts cleverness. Derek called twice that day. I did not answer. I let both calls go to voicemail and did not listen to the messages. Tom had said don't confirm or deny anything, and I had learned enough about my son to know that a phone conversation with him was an opportunity to be maneuvered, not informed. Whatever he had to say could wait until I was standing on better ground. Monday morning, I was at Tom Hargrove's office on Broad Street at 5 minutes to 8. Tom Hargrove was 64, silver-haired, and had the manner of a man who had spent 4 decades hearing people's worst news and taking it seriously without being destroyed by it. He had handled Roy's estate, both our wills and the trust restructuring in 2019. He knew our paperwork the way a doctor knows a long-term patient, not just the facts, but the history behind the facts. I laid everything on his conference table, the original trust document. The deed I had photographed from the county portal, the Buick title, which was registered to the Callahan Family Trust as well, a detail I hadn't mentioned to Derek because it had never seemed necessary. Tom put on his reading glasses and went through each document in careful silence. After about 15 minutes, he set the glasses down and looked at me. "Peggy," he said, "Derek had no legal authority to sell either asset. The cottage was trust property. The vehicle title lists the trust as owner. He is not a trustee. He has no power of attorney. Whatever signatures appeared on those documents were not obtained with your consent?" "I was in Savannah," I said. "I never signed anything." Tom nodded slowly. "Then we are looking at deed fraud, title fraud, and potentially wire fraud if the proceeds crossed state lines or went through electronic transfers. This is not a civil dispute. This is criminal." I had known that intellectually since Saturday. Hearing Tom say it aloud in his careful lawyer's voice made it solid in a way it hadn't been before. "What do we do first?" I asked. "First, I file an emergency motion to void the deed transfer on the basis of fraudulent conveyance. The trust was the legal owner, the transfer was unauthorized, and the recorded deed is invalid." That goes to the court today. Simultaneously, we report to the Charleston County Sheriff's Office and the South Carolina Attorney General's Fraud Division. You will need to give a formal statement. And the buyers? I asked. The people who bought the cottage? Tom's expression was careful. The buyers may be innocent parties, which complicates the real estate picture. But a void transfer means the property legally never left the trust. The court will determine remedies for the buyers against Derek, not against you. Your property rights were never extinguished because Derek had no authority to extinguish them. I sat with that for a moment. $800,000. Not gone. Stolen, yes. But not gone. Let's begin, I said. While Tom's paralegal began preparing the emergency motion, Tom walked me 2 blocks to the sheriff's office on Lockwood Drive. I sat across from a detective named Hale, a calm, deliberate woman in her 40s, and gave a complete statement. I brought my documents. I brought the photographs. I told her about the deed transfer I had found online, about the car, about the fact that Derek had called me on Friday afternoon and laughed. Detective Hale took notes and recorded the interview. She told me an investigation would be opened and that I should not confront Derek directly. She said they would need to obtain financial records and that I should expect this to take time. Time. Did I have time? Derek had the sale proceeds somewhere. Money moves fast when someone is motivated. That was the thing worrying me as I walked back to Tom's office. Derek wasn't stupid. He was lazy and impulsive, but he wasn't stupid. And Brittany was sharper than he was in certain tactical ways. She understood how to move money through accounts, how to create plausible distance between a transaction and its source. What I didn't know yet, what I found out that same Monday afternoon, was that Derek had already begun to sense something was wrong. Tom's office called me at 3 o'clock. His paralegal, a young man named James, said that while filing the emergency motion, they had discovered that Derek had contacted the Charleston County Register of Deeds office that morning, 2 hours after my visit to Tom's office, and requested copies of the deed transfer documents. Why would Derek request those documents Monday morning unless someone had told him the deed was being examined? Nobody had told him, which meant Derek had been monitoring the property record online himself. He had a search alert on the address. He was watching. He had been watching all along. That changed things. It meant Derek knew that scrutiny had begun, even if he didn't know the exact shape of it yet. It meant the window before he started covering his tracks was shorter than I had hoped. I called Diane from Tom's waiting room. I spoke quietly because the chairs near me were occupied. He's already moving, I said. Then you move faster, she said. She was right, and as it happened, we already had more than Derek realized, because James, doing the deed research, had found something else, something that turned this from a difficult case into an airtight one, the signature on the fraudulent deed transfer. The signature, purporting to be that of the trustee of the Roy and Margaret Callahan Family Trust, had been notarized by a notary in North Charleston named Patricia Wynn. Patricia Wynn was Brittany's cousin. Patricia Wynn had a notary commission registered with the South Carolina Secretary of State's office. Tom pulled her public record before 5 o'clock that Monday. She had been commissioned 3 years ago and had no prior complaints. She was also, according to Brittany's public Facebook profile, which Tom's paralegal checked with professional thoroughness, listed as a bridesmaid at Derek and Brittany's wedding 9 years ago. A notary is not permitted to notarize a document in which she has a personal interest or a close relationship to a benefiting party. Notarizing a deed that transferred property fraudulently for her cousin's husband was not a clerical error. It was, at minimum, a violation of her commission and, given the surrounding circumstances, potentially criminal facilitation. Tom submitted the emergency motion to void the deed at 4:40 that afternoon. He also forwarded the notary information to Detective Hale. The court issued a temporary hold on the property pending a hearing scheduled for the following Wednesday. The deed transfer was flagged. The title to the Sullivan's Island cottage was, for legal purposes, frozen. The Buick was a separate track. Tom contacted the DMV through proper legal channels to flag the title transfer. The car had already been sold to a private buyer, a young man in Somerville who had paid Derek $14,000 in cash. That recovery would be more complicated, but Tom said we had a solid civil claim against Derek for the market value difference. I went home Monday evening and ate soup from a can, and felt for the first time since Friday something that was not quite peace, but was adjacent to it. The paper trail was real. The evidence was documented. The legal machinery had started turning. Derek called at 9:15 that evening. I looked at his name on my phone screen. I did not answer. He called again at 9:40, and at 10, and at 10:20. Then the calls stopped. I went to bed. I slept better than I expected. At 11 o'clock Tuesday morning, I heard a car in my driveway. I looked out the front window and saw Derek's black Ford F-150 parked at the curb. Derek and Brittany got out. Brittany was wearing sunglasses even though the sky was overcast. Derek was walking with the slightly too deliberate stride of a man who had rehearsed this approach. I let them knock twice before I opened the door. I did not invite them in. I stood in the doorway. "Mom?" Derek said. His voice had changed from Friday's breezy confidence. It was controlled now, careful. "We need to talk." "I don't think we do," I said. Brittany stepped forward slightly. She was 38, blonde, and had the particular skill of people who have spent their lives using emotional pressure as a tool. "Peggy," she said, using my first name the way she always did when she wanted to seem like an equal. "We understand you're upset, but Derek made decisions under real financial pressure, and we think if you just—" "I spoke with my attorney yesterday," I said, "and with the sheriff's office. I gave a formal statement." The change in Derek's face was small, but absolute. The careful control slipped. Just for a second. Just enough. His jaw tightened. His eyes went flat. "You went to the police," he said. It was not a question. "I reported a crime," I said. "Yes." "Mom." His voice dropped. The charm was gone entirely now, and what was underneath it was something I recognized from when he was a teenager, and I had caught him in a serious lie. Not remorse, but calculation. "You don't understand the full picture. There are things here that could look very bad for you if this goes to court. Things about how the trust was structured, questions about whether the language—" "Tom Hargrove drafted that trust," I said. "He also filed the motion to void the deed yesterday afternoon." Brittany made a short sound that might have been a laugh or a curse. She turned away from the door and pressed her fingers to her forehead. Derek leaned forward slightly. "If you push this, you're going to put your own son in prison. Is that what you want? Over a house?" "Over a house that you stole," I said, "and a car, and 30 years of my husband's work." "We can pay you back," Brittany said, spinning back around, her voice sharp now. "We can work out a payment plan. This doesn't have to be a legal situation." "It's already a legal situation," I said. "That happened when you forged a trust document and had your cousin notarize it. That landed." I watched it land. Brittany went very still. Derek looked at her, then back at me, and for the first time in his adult life, he appeared genuinely, completely afraid. "You can leave now," I said. I stepped back and closed the door. I stood in my hallway with my back to the door and my heart hammering and waited to hear if they would knock again. They didn't. After a moment, I heard the F-150 start and pull away. I called Tom and told him about the visit. He said to document it, time, participants, what was said, and he told Detective Hale. She noted it as a potential witness intimidation contact. That afternoon, I packed a small bag and drove Ruth's borrowed car to Diane's house in Mount Pleasant. Diane made chicken and rice. Real chicken and rice, not from a can. And we sat on her screened porch in the mild October evening and talked about things that had nothing to do with deeds or notaries or the specific cruelty of children who mistake a mother's patience for passivity. I stayed 3 days. I needed it. Not because I was giving up, but because what was coming was going to require me to be steady, and steadiness requires rest. I drove back to Charleston on a Friday morning. The hydrangeas in the front garden needed water. I took care of them first before I even brought my bag inside, because Roy had planted them, and they deserved better than to suffer for someone else's crimes. There were 3 voicemails waiting on my home phone. I still had a landline. Roy had insisted on it, and I had kept it the way I kept several of his habits, as a form of continuity. The first message was from Tom, asking me to call when I was back. The second was from a number I didn't recognize. The third was Derek. Derek's voice on the message was different from anything I had heard from him in the 42 years he had been alive. It was softer, more careful. He said, and I played this back twice to make sure I was hearing it correctly, that he had been doing a lot of thinking, that he understood he had made serious mistakes, that he was not asking me to drop anything just to have one conversation, one meal even, that he had some money set aside. He used the phrase first installment, that he wanted to give me as a gesture of good faith. First installment. As if he could buy his way out of a felony with installment payments. I called Tom first. He had updates. The court hearing on the deed void was confirmed for Wednesday. Patricia Wynn's notary commission had been suspended pending investigation. The buyer of the Sullivan's Island cottage, a couple from Atlanta named Moorfield, had been informed of the disputed title and had engaged their own attorney. They were cooperating with the process and had filed a claim against Derek for breach of the sale contract. Derek's exposure was expanding in every direction. "How is he handling it?" I asked Tom. "From what I can tell, badly," Tom said. His previous attorney withdrew. He appears to be attempting to negotiate with multiple parties simultaneously, which rarely goes well. After I hung up with Tom, I called the unknown number back. It turned out to be a woman named Sandra Pryor, who worked with the South Carolina Attorney General's Elder Financial Abuse Unit. She had been assigned to my case as a parallel track alongside Detective Hale's investigation. She was efficient and kind, and she explained that what Derek had done fell clearly within the state's definition of elder financial exploitation, a serious felony carrying significant prison time. I was 68, not 90. I had all my faculties. I resented slightly the category of elder, but I understood its legal usefulness, and I thanked Sandra Pryor sincerely. It was later that same Friday afternoon that Derek and Brittany made their attempt at what I can only call seduction. The offer designed to make everything go away before Wednesday's hearing. Derek arrived alone this time. No Brittany. He stood on the porch steps with a manila envelope and an expression of such carefully constructed remorse that, 2 months earlier, it might have worked. "Mom," he said, "can I just leave this with you? I'm not asking you to make any decisions. I just need you to know that I'm trying to make it right." I stood inside the screen door. "What's in the envelope, Derek?" "A cashier's check. $50,000. It's not everything, I know that. But it's real, and it's yours. And there's more coming, I swear to you." $50,000 against $800,000 and a car and 3 weeks of my life and 42 years of choosing to love someone who had spent the last year calculating how to rob me. Was he serious? Did he believe truly that I was the kind of woman who could be bought back into silence with a cashier's check? "Derek," I said, "if I accept that check, I complicate the legal proceedings. It could be characterized as partial settlement, which muddies the fraud claim. Your attorney would know that, which means you don't have a new attorney yet, or the one you have told you to try this." He blinked. The remorse flickered. "Leave," I said. "Take the envelope." He left. He didn't say another word. He walked back to his truck with the manila envelope and drove away, and I watched from the screen door until the truck was out of sight. Then I called Carol Whitmore, my neighbor from Sullivan's Island, who had first told me about the real estate agents walking my property. I told her what was happening. Carol was 66 and had worked 30 years as a paralegal before retirement. She listened, and then she said something that mattered to me more than almost anything else that week. "Peggy," she said, "everyone on this island knew that cottage was yours. I will testify to that. Whoever needs to hear it, whenever they need to hear it." That was the social support I needed, not pity. Witness. Over that weekend, 3 more people came forward to Tom's office. My neighbor from Sullivan's Island on the other side of the cottage, a retired contractor who had done work on the property twice and had my signed checks as proof of ownership, and a woman from the island's community association who had corresponded with me about HOA fees as recently as July. All 3 were prepared to provide affidavits. The world was not standing aside for Derek and Brittany. The world was watching, and the world remembered the truth. I planted new impatiens along the front walk that Saturday. Roy had always said you could measure a person's faith in the future by whether they kept planting things. I planted 2 flats of impatiens and watered them well, and felt, for the first time since October, something very close to peace. They came together on a Tuesday evening, 4 days before the court hearing. I saw the F-150 from the kitchen window. Brittany was carrying a casserole dish. If I hadn't been so angry, I might have laughed. I opened the door before they knocked. Brittany smiled. The wide, practiced smile she deployed at family holidays when she wanted something from me. "Peggy," she said warmly, "we brought dinner. We just want to talk like a family. No lawyers, no—" She made a small, dismissive gesture. "All of this." I looked at my son. Derek had dressed carefully. Pressed shirt, clean shave. He looked like a man going to church. "You can come in for 10 minutes, I said. "But I have nothing to decide tonight, and I won't be changing my position. So if that's the purpose of the visit, we should be clear about it up front." They came in. We sat at the kitchen table. Brittany set the casserole on the counter without being asked where to put it. That minor presumption, treating my kitchen like it was already negotiated territory, told me everything about where this conversation was actually headed. Derek began gently. He talked about the pressure he'd been under, a business debt that had come due faster than expected. He owed money to people who were not patient about repayment. He used the word dangerous once, briefly, in a way designed to suggest threat without specifying it, to make me imagine consequences for him that were worse than consequences from the law. He said he had panicked. He said he had made terrible decisions. He said he was sorry. He was good. He had always been good at this part. Brittany took over when Derek paused. She talked about family, about what a trial would do to all of us, the publicity, the stress, Derek's health. She mentioned almost offhandedly that Derek had been having chest episodes under the pressure of recent weeks. She looked at me with an expression calibrated to suggest that I, as his mother, bore some responsibility for his cardiac wellness. "I know you're hurt," Brittany said, "but you have to ask yourself, is destroying your son's life going to make you feel better? Is it worth a family?" There it was, the pivot. The suggestion that my legal rights were a form of selfishness, that withdrawing from the truth was what a good mother would do, that the crime was less important than the family structure the criminal lived within. "What exactly are you asking me to do?" I said. Derek leaned forward. "Just slow down. Ask Tom to delay the hearing. Give us a chance to work something out privately. If the hearing goes forward Wednesday, Peggy—" He paused, and his voice shifted. "Things are going to come out that are complicated. About the trust. About whether you understood what you were signing in 2019. Tom isn't infallible. We have someone looking at the trust language, and there are questions about whether you had capacity." I went very still. There it was. The real threat, offered in the smooth tones of family concern. They intended to challenge my mental capacity at the time of the trust's creation, to argue that a 65-year-old woman who had just retired from 30 years of bookkeeping had not understood the documents she signed with her attorney of 15 years. It was an ugly play. It was also a desperate one, which meant their situation was worse than they were showing. "Tom's paralegal has a video recording of our 2019 trust meeting," I said quietly. Tom recorded all estate planning sessions after a malpractice case in 2017, taught him the value of documentation. That recording will show a 65-year-old woman asking precise, informed questions for approximately 45 minutes before signing anything. Brittany's expression didn't change immediately, but her hands, which were folded on the table, went very slightly still. "You should go," I said. "Dinner can stay or go. I don't mind either way." Derek stood up. The careful husband, the pressed shirt, all of it dropped at once. What looked back at me from my kitchen was someone I recognized and someone I didn't, simultaneously. "You're making a mistake," he said. It wasn't loud. Quiet threats are always the ones that find the bone. "I've made mistakes," I said. "Trusting you too long was one of them. I won't make it again." They left. Brittany took the casserole. I sat at the kitchen table after they drove away. My hands were shaking slightly. Not from fear, exactly, but from the sustained effort of remaining calm during something that was fundamentally terrifying. Because it was terrifying. The idea that my own son would challenge my mental capacity in open court, that he would stand in front of a judge and argue that his mother was diminished. But fear, I had learned in 68 years, is information. It tells you what matters. And what this fear told me was not to retreat. It told me that retreat was impossible. Because if Derek was willing to attack my competence, he would do it whether I fought or not. Better to fight from a position of strength. I called Tom at 8 o'clock that evening and told him about the capacity threat. He was quiet for a moment. "The video," he said, "is quite good, Peggy. I'll have James get it formatted for submission by morning." "Thank you," I said. "Get some sleep," he said. "Wednesday is going to be a good day." Wednesday arrived with the particular clarity of a South Carolina autumn morning. The sky a clean, hard blue, the air finally cool enough to mean something. I put on the dark green dress I had worn to Roy's retirement dinner in 2003, because Roy had said that day that I looked like someone nobody should argue with, and I felt the truth of that description more acutely than I ever had before. Tom met me outside the courthouse on Broad Street at 8:45. He had a leather folder under his arm and the expression of a man who had reviewed his documents and found them satisfactory. "Ready?" he said. "Been ready since Friday in October," I said. The hearing was in a civil court, before Judge Patricia Ann Sorrells, who had the reputation, according to Tom, of running an efficient, facts-based courtroom with limited tolerance for melodrama. I found this encouraging. Derek arrived with an attorney I hadn't seen before, a younger man named Graff from a firm in Columbia. Brittany sat in the gallery, in a dark blazer, with the rigid posture of someone trying to appear unconcerned. Derek did not look at me when he came in. That told me something. The Moorfield couple, the buyers from Atlanta, were also present, with their attorney seated on the opposite side from Derek. They were a neat couple in their early 50s. The woman caught my eye briefly and gave me a look that contained no hostility, only the specific resignation of people who had discovered that the house they purchased did not, legally, belong to the man who sold it. Judge Sorrells opened the proceedings efficiently. Tom presented the motion to void the deed transfer. He submitted, in sequence, the original trust document naming me as sole trustee, the deed of transfer recorded 11 days ago, bearing a signature purporting to be mine as trustee, the notarization by Patricia Wynn, documentary evidence of Patricia Wynn's familial relationship to Brittany, Tom's own video recording of the 2019 trust signing meeting, and affidavits from Carol Whitmore, the contractor, and the HOA representative. It took Tom 14 minutes to present this material. He was calm and methodical. He didn't editorialize. Graff, Derek's attorney, rose and offered the defense argument. It was, as I had anticipated, built on two planks. First, that there had been a verbal authorization from me, that I had told Derek he could handle the property if financial circumstances required it, and second, a veiled suggestion that the trust document itself might have been signed under diminished understanding. Judge Sorrells let Graff finish. Then she looked at him with an expression I recognized from 30 years of watching people receive accurate information they didn't want. Counsel, she said, you are asserting a verbal authorization for a trustee to transfer trust real property. Are you aware of the statute of frauds? Graff began to explain that verbal authorizations, the statute of frauds, Judge Sorrells said, slightly more precisely, requires that any transfer of real property be in writing. A verbal authorization, even if proven, which your evidence has not established, is legally insufficient to convey trust property. Is that the foundation of your defense? The silence from Graff's table lasted approximately 4 seconds. 4 seconds is a very long time in a courtroom. Tom passed me a note. It said, "That's it." Graff pivoted, gamely, to the capacity argument. Judge Sorrells asked to see any medical or psychological evidence supporting a claim of diminished capacity in 2019. Graff had none, because there was none. He mentioned the possibility of obtaining expert testimony. Tom then asked permission to play the recording of the 2019 trust meeting. The judge granted it. The courtroom listened to 47 minutes of audio and partial video. A woman, clearly and precisely, asking her attorney to explain the difference between a revocable and irrevocable trust, questioning the implications of her son not being named as trustee, asking whether a future trustee could be designated in case of her own incapacity, and finally, in her own clear voice, confirming that she understood all documents before signing. That woman in the recording was me at 65. She sounded exactly like me now. When it finished, Judge Sorrells looked at Graff again. He said carefully that they would not be pursuing the capacity argument further. Then something happened that Tom had not fully predicted. Judge Sorrells looked directly at Derek. "Mr. Callahan," she said, "you signed a deed as trustee of a trust in which you hold no position of authority. You submitted that deed for recording. Can you explain to the court the basis on which you believed you had that authority?" Derek's attorney put a hand on his arm. Derek shook it off. And then Derek Callahan, my son, who had spent 42 years talking his way through everything, opened his mouth. "The property was always going to be mine eventually," he said. "She's 68. It was going to come to me. I needed it now." The room was very quiet. Tom wrote on his notepad. He just said the quiet part out loud. I looked at my son across the courtroom. He looked back at me finally. And in his face I saw, for the first time, not cunning or charm or the performed remorse he'd deployed on my porch. I saw the actual shape of what he had believed about me all along. That I was a temporary condition. That I was an asset waiting for transfer. That my decades of careful work had been, in his mind, always his money in someone else's account. It was the saddest thing I had seen in 11 years. The last thing sadder had been Roy's face in the hospital room. Judge Sorrells voided the deed transfer. She found the transfer fraudulent and without legal authority. She referred the matter formally to the county prosecutor's office and to the AG's Elder Financial Exploitation Unit. She ordered Derek to produce all financial records related to the sale within 10 days. She also said, before adjourning, that the court had rarely seen a case in which the documentary evidence was more straightforwardly dispositive. She said this without looking at Graff, but Graff appeared to feel it anyway. The criminal process moved with a deliberateness I had not expected. Sandra Pryor at the AG's office had told me that fraud cases often moved slowly, stalled in paperwork, collapsed under the weight of their own complexity. This one did not. What helped was Derek's statement in the courtroom. Tom told me afterward that a person's candid admission in a recorded proceeding before a judge that they had transferred property because it was going to be mine eventually effectively closed the question of criminal intent. Intent is often the hardest element to prove in fraud cases. Derek had provided it, unprompted, to a courtroom full of witnesses. The Charleston County prosecutor filed charges 6 weeks after the hearing. Derek was charged with deed fraud, title fraud, and financial exploitation of a vulnerable adult, the last charge carrying, under South Carolina law, a sentence of up to 10 years. Brittany was charged separately as an accessory based on her coordination with Patricia Wynn and evidence from bank records that showed the sale proceeds. $340,000, a discounted sale price Derek had arranged in his panic, had flowed through an account held jointly by Derek and Brittany before being partially disbursed to various creditors. Patricia Wynn cooperated with the prosecution in exchange for a reduced charge. She provided a detailed account of how Derek had approached her, what he had told her about my agreement to the sale, and how she had notarized the document knowing I had not appeared before her. Her testimony was devastating to Derek's remaining defense. The civil recovery ran parallel to the criminal case. The Moorfield couple, who were innocent purchasers, had their own damages claim against Derek for the failed sale. A court-ordered accounting found that Derek had received $218,000 after the deal costs and his immediate debt payments, money that had moved through 4 accounts in 11 days. The forensic accountant Tom hired traced every transaction. The Buick recovery was simpler. The young man in Somerville who had bought the car had no idea it was not Derek's to sell. Under South Carolina law, a fraudulent transfer of titled property voids the sale. The man received his $14,000 back from Derek's seized assets, and my car was returned to me. Somewhat dirty from 11 weeks of a 24-year-old's custody, but structurally sound. I drove my Buick home from Somerville on a cold December afternoon. I stopped at the Sullivan's Island Bridge and looked at the water. The same water Roy and I used to look at from the cottage porch, drinking coffee in the early mornings, not saying very much because we didn't need to. The cottage was mine again. The deed void had held. The legal title had been returned to the trust without complication. There was some work needed. Derek and Brittany had clearly used the property carelessly during those months, but Carol Whitmore had kept an eye on it, and the structure was sound. I sat on the bridge overlook for about 10 minutes. A pelican landed on the railing nearby and regarded me with magnificent indifference. Derek pleaded guilty in March. His attorney had apparently advised him correctly that going to trial against the recording and Patricia Wynn's testimony and his own courtroom statement was not a survivable strategy. He received 4 years, with the possibility of parole after 2, conditional on full financial restitution. The restitution order covered the original sale price gap and legal costs. Brittany's case resolved separately. She received 18 months of supervised probation and community service, a result that reflected her cooperation with the prosecution and the argument that her primary role had been facilitation rather than origination. She did not go to prison. I am not sure how I feel about that. I have decided that the criminal justice system is not required to satisfy my feelings, only to approximate justice, which it did reasonably well in this case. I did not attend the sentencing hearing for Derek. Tom offered to accompany me. I thought about it for a full week. In the end, I decided that watching my son receive his sentence was not something I needed to witness in order to be finished with it. I knew the outcome by phone before noon that day. When Tom called me with the sentence, I was in the Sullivan's Island cottage. I had driven out that morning to begin assessing what needed repair. I was standing in the kitchen, the small kitchen with the yellow curtains I had put up in 1994, when my phone rang. I said thank you. I hung up. I looked out the window at the water. Then I made a list of what the cottage needed. New paint on the porch railing, 2 windows with cracked sealant. The outdoor shower drain was blocked. A section of the garden fence had come loose. None of it was beyond fixing. None of it was beyond me. The spring after Derek's sentencing was the best spring I could remember in years. That might sound strange, given everything. But there is a particular relief that comes after a long period of sustained tension. A quality of air and light that you had forgotten was available to you. I hired a contractor named Marcus Webb, who had been recommended by Carol Whitmore, to do the repairs on the Sullivan's Island cottage. He was 60, careful with wood, and had strong opinions about the right primer for coastal conditions. We spent 3 weeks working through the repair list, and by April, the cottage looked better than it had in years. I replaced the yellow kitchen curtains. They had been faded and slightly salt-damaged, with new ones in a blue-green that matched the color of the water on clear days. I did not rent the cottage. For a while I had considered it. The income would have been comfortable. But I decided that the cottage was not a financial instrument. It was a place Roy and I had loved, and I was going to use it accordingly. I went out on weekends in the warm months. I had Diane and her sister out in June, and we sat on the repaired porch and ate shrimp from the market and watched the light change over the water. Tom Hargrove updated my estate documents comprehensively. The trust was amended to include additional layers of clarity and a corporate co-trustee arrangement, a local bank's trust department, that would make any future unauthorized action essentially impossible. My will was revised. I added a provision that made charitable organizations, rather than any individual family member, the residual beneficiaries of the trust in the event of what Tom delicately called contested circumstances. I found in going through this process that I felt no bitterness about it, only the clean satisfaction of a thing done correctly. Sandra Pryor from the AG's office asked if I would be willing to speak with other elderly women who had experienced financial exploitation by family members. I said yes. I spoke to 3 women over the following months. On the phone, mostly, because 2 of them were not mobile. What I told them, each time, was the same thing. Document everything, trust your attorney, and do not mistake love for obligation. You can love someone and still hold them accountable for what they have done. Diane said I should write a book. I told her I had enough to do. Carol Whitmore and I became closer friends in that period. She had been a paralegal for 30 years and had seen a great deal of what people will do to other people for money, and she had the particular warmth of someone who has seen the worst and not been ruined by it. We walked the island most Saturday mornings when the weather allowed. It was a good routine. As for Derek, he served 14 months before being granted parole on the conditions set by the court. He was released in May of the 2nd year. I knew this because Tom's office tracked it. I needed to know for my own security, not for any other reason. Derek did not contact me after his release. I don't know whether that was the condition of his parole or his own decision. Either way, I was not contacted, and I did not reach out. Brittany had filed for divorce while Derek was still incarcerated. That surprised some people, but it did not surprise me. Brittany had always been practical in the way that some people are practical. Not principled, but calibrated. Being married to a convicted felon on a restitution order was not a calculation that worked for her. She moved back to her family in Georgia. I have no information about her subsequent life, and I have not sought any. Derek, on the last report I received, was working a labor job in Colombia and living in a rented room. He was meeting his restitution payments minimally, which extended the repayment timeline, but technically kept him in compliance with his parole conditions. His business career, such as it had been, was over. No contractor would extend him credit, no partner would engage with him, and his name in the financial world was associated with a public fraud conviction. I thought about him sometimes. Not with anger, after a while. With something more like sorrow. The sorrow of understanding exactly how someone went wrong and knowing that understanding doesn't fix them. Derek had looked at a 68-year-old woman who had worked her entire life and had seen an asset. He had looked at his father's name and his father's effort and had seen an opportunity. That was a poverty of character that no court order could remedy. But it was not my poverty, and it was not my responsibility to carry it any further than I already had. The summer was warm. The cottage windows were closed against the heat most afternoons and open at night to catch the breeze off the water. I read through most of the library's collection on coastal plant species and replanted the cottage garden with things that could survive the salt air: sea oats, beach roses, native grasses. Roy would have approved. He had always preferred plants that were honest about what they needed. In September, almost exactly a year after I had come home to an empty driveway and my son's laughter, I drove my clean Buick to Sullivan's Island, made coffee, and sat on the porch in the early morning light. The mockingbird was back. Or another one. They're impossible to distinguish, which I have always liked about them. It sang for a while, and I listened, and the water was there, exactly as it had always been, and the morning was quiet, and mine. What did I learn? Document everything, trust your instincts, and never confuse love with obligation. You can love someone fully and still hold them accountable. Derek saw an old woman and thought he saw an easy target. He forgot that quiet people keep records. The cottage is mine. The Buick is in my driveway. The mockingbird still sings. If someone is slowly taking what is yours, don't wait. Act while you still can. What would you have done in my place? Tell me in the comments. I genuinely want to know. Thank you for listening. This was Peggy Callahan.